We know from the scene setting video, part 1, that the reason this case is important is because of the stark contrast between the positions taken on things like the interpretation of a constitution, the role of natural law, the role of judges in a democracy, and so on, between the majority judges on the one hand and the dissenting judge, Chief Justice Kennedy, on the other. We'll get to that and we'll explore it, but first we need to go through just some technical features of the case, and we must begin, I suppose, with Article 50, which I think I mentioned in that scene setting part 1. Video, this is a technical amendment provision of the Free State Constitution. It provides basically that in order to amend the Constitution, the people must approve in a referendum. That's the normal route. However, late in the drafting process, we understand, a mechanism was inserted into Article 50 allowing the Oireachtas, really allowing government, seen as government controls the Oireachtas, to amend the Constitution for a period of 8 years by ordinary legislation. Just simply by passing legislation through the Oireachtas, it could amend the Constitution. So we call that the legislative amendment provision in Article 50. Now, this was, we understand, as I say, inserted late in the drafting process. We understand that because Hugh Kennedy, who was the dissenting judge in 1935, in this case, State Ryan and Lennon, had been on the drafting committee of the Free State Constitution in 1922, and he tells us in academic writing that he contributed in the 1930s to Leo Cohen's book on the Constitution. In the preface, he tells us that this was the intention all along. It was simply to facilitate kind of housekeeping tweaks of the Constitution. In other words, not dramatic or important constitutional amendments, but little tweaks that might emerge that, as necessary in the early few years of the Constitution as things began to bed down. The second one, of course, is a little maybe dangerous, you might say, in the sense that it meant that political actors who control the Oireachtas could press through dubious amendments to the Constitution. There was some provision guarding against that possibility. The drafters inserted safeguards providing that if a majority of the Seanad, the upper house of Parliament, was dubious about a particular proposed legislative amendment, it could block it, or indeed if 2/5 of the Dáil was similarly dubious, it could block it. So these are little safety valves, if you like, that were inserted. This brings us to the 3 notable legislative amendments of the Irish Free State Constitution that bring about, if you like, or that are relevant to State Ryan and Lennon. The first of them passes kind of quietly through the Oireachtas in 1928. Within that 8-year period, the Oireachtas passes the number 10, the Constitution Amendment number 10 Act of 1928, which simply removes the safety valves I mentioned. The second of these legislative amendments is the following year, 1929, just as the 8 years is about to expire, the 8-year period is about to expire. The Oireachtas passes a piece of legislation, the Constitution Amendment number 16 Act of 1929, that extends the 8-year period by a further 8 years. So you're seeing that kind of trickle of concentration of more and more power over the Constitution in effectively the government, if you like. And I suppose maybe it calls to mind that kind of drip democratic decline that we see in, for example, modern day Hungary. It doesn't all happen in one glorious go, if you like, but rather it kind of slides over time. Then the third, and I suppose this is the dramatic moment, is the Constitution Amendment number 17 Act, which is enacted in 1931. Now, of course, you've got to bear in mind that the 1931 Act, which I'll talk about now momentarily, is passed after the expiration of the initial 8-year period, but in the period, the second 8-year period. So the Constitution Amendment number 17 Act of 1931 is this very lengthy piece of legislation. It's like 15 or 20 pages long. It's almost as long as the Constitution itself. What does it do? Well, essentially, it inserts a new article, Article 2A, into the text of the Free State Constitution itself, and it renders, in I think Section 2, all Article 3 and all other articles, subsequent articles of the Irish Constitution, subordinate to Article 2A itself. In other words, what it does really is it establishes a parallel legal system, or a parallel or extra-constitutional legal system. If you like, it establishes a special powers military tribunal, basically with arbitrary powers to deal with terrorism. Of course, there's a context to this. Ireland had gone through a pretty bitter civil war from 1922, which I guess kind of spluttered on in one way, form or another for a good few years, probably until the mid-1920s. And even still, there was a strong anti-treatyite resentment, if you like, into the late 1920s. For instance, the Minister for Justice of the day, Kevin O'Higgins, was assassinated on his way to Mass on a Sunday morning in Booterstown in County Dublin in 1927. So, of course, there's a context to all of this. In any event, the government of the day, this is into 1931 now, establishes this extra-constitutional military tribunal under this 1931 Amendment Act. It is to be comprised of 5 judges, effectively, members of the military defence forces, no requirement that they would have legal training. They could be appointed and dismissed by the Minister for Justice or government at will. In other words, judicial independence that's protected in the Article 63, I think, of the Free State Constitution is cast aside. This military tribunal had authority under this provision to try any one of a pretty significant range of offences set out in an annex to the legislation, including a right to retrospective legislation. Now, I think I mentioned earlier on Article 43 of the Free State Constitution, which expressly prohibits retrospective legislation. Yet, well, I suppose, of course, it's exempt or immune, but a provision of the Article 2A allowed the tribunal to try any offence whatsoever, bracket, whether committed before or after this article was inserted into the Constitution, in respect of which the executive minister certifies in writing, to the best of his belief, the act constituting such offence was done with the object of impairing or impeding the machinery of government or the administration of justice. In other words, they can make up the rules as they go along, if you like, or convict and ultimately impose the death penalty on somebody for committing an act which, when it was committed, was not in breach of any law. And that, I suppose, brings us back to our 4 friends in the Tipperary farmhouse in August of 1934. Article 2A at this stage is very much established as part and parcel of the Irish Constitution. It's 3 years old at this stage. There has been a change of government. It was a Cumann Gael government that had introduced Article 2A in the first place, a Cumann Gael government that had passed the number 10 Amendment Act, the number 16 Amendment Act, and the number 17 Amendment Act. Then there had been a general election. Now, the Minister for Justice, I suppose a Fianna Fáil Minister for Justice, happily used the authority that he, as Minister for Justice, or this Fianna Fáil government enjoyed because of the actions of its predecessor, if you like, and it happily certified that this particular episode should be prosecuted through the extra-constitutional system rather than through the ordinary criminal justice system. These guys were blue shirts, I suppose, and blue shirts you associate with Cumann Gael rather than with Fianna Fáil. So that's kind of a little political side story, if you like. In any case, that brings us to 1934. Our four friends are not very happy about this. They're being detained in Arbor Hill military barracks. The head of that barracks is a guy called Captain Lennon, hence the state Ryan versus Lennon. If you like, they're seeking habeas corpus, review of their detention. They argue that their detention is unconstitutional, they say, because the First Amendment, the number 10 Amendment in 1928, had been an unconstitutional abuse of Article 50, they said. So too then the following, the 1929 Amendment, the number 16 Amendment, extending the 8-year period by a further 8 years, that, they said, was an unconstitutional abuse of Article 50, which in turn meant that the number 17 Amendment, the 1931 Act, was unconstitutional. So effectively, of course, what they're arguing is that a provision of the Constitution is unconstitutional. Article 2A is unconstitutional. In other words, they're arguing that this was an unconstitutional constitutional amendment, if you like. So that kind of sets the scene then for the judgments. They seek this habeas corpus application in the High Court. They lose 3-0 in the High Court. They appeal to the Supreme Court, and that brings us then to this great judgment, our case, State Ryan and Lennon. So I'll see you in video number 3.